and welcome to What Happens Next, a series curated as part of SAHAS's ongoing endeavor to equip survivors and active bystanders with information toward empowered decision-making. Today, I'm joined by Sithara Sarangan, a lawyer, to discuss what happens next in the specific context of prosecuting gender-based and sexual violence. Hi, Sithara. Thank you for making time for this and welcome to What Happens Next.
Hi, Kirti. Thank you so much for having me on this forum today. I think what you're doing is very interesting and it's also very pertinent to what's happening right now in the area of violence against women or against gender-based violence largely. So thank you. I hope it's going to be an interesting discussion.
I'm sure, Sithara. Thank you so much for that. Let me start by inviting you to introduce yourself to our listeners, to our viewers, and to folks who will be reading the transcript.
Yes. So, hi, my name is Sithara. I'm Sithara Sarangan. I am a practicing advocate at the Madras High Court. And a little background about myself. I did my undergrad here in Chennai, and then I did my postgrad at University College London. And my thesis was in constitutional law. So since then, in one way or another, I've been engaging with constitutional law. And I've been writing also simultaneously. After I came back to India, I joined the Advocate General's office. So that was a big learning experience for me. And I got to work on a lot of matters of public importance. Although criminal law wasn't really my area of expertise or specialization, I was forced to work on a lot of criminal law matters at the AG's office, a lot of matters of commutation and sentence, death sentence and all of that, which is very interesting. So I also made time to keep in touch with academia, and I write legal op-eds on matters that are pertinent in the legal sphere. So I recently had written about the Tarun Tejpal verdict that was given out. At the moment I work with a law firm called Focus Law here in Chennai and do broadly civil constitutional litigation and taxation. So, yeah.
Brilliant. Thank you so much, Sithara. And I think that's already food for thought for so many people to engage with your work. So let's get right into today's conversation. When a person faces an instance of gender-based or sexual violence, is it mandatory for them to press charges?
No, it's definitely not mandatory to press charges. So the system has been designed in such a way that it is completely at the instance of the person who's faced the violence. Of course, the wiser thing for someone to do would be to approach an authority, law enforcement authority, to go to a police station and report the crime, but it's absolutely not necessary for one to do so.
That's a really very, very useful insight to have, because a lot of times survivors have held back from even articulating what happened to them to even a family member, fearing that it would have to be reported mandatorily. Right. So if they decide not to report a case, not to press charges, but at least report a case to the police, what happens to their case after they file a report to the police?
So ideally, an FIR would set things in motion. So if it's only been a complaint that's been filed, nothing really happens there unless the survivor decides to pursue the case. Once an FIR has been registered, though, things start to get a little complicated because there is a process in motion there. After the FIR, the police have, they have to do an investigation, they have to file the charge sheet, and then it goes to the magistrate. So there is a series of process. So at that point, for someone to turn back would be quite hard, but that's largely how it works.
So there's an overarching notion that the crime is considered to be not only the crime against a person, but also against the state. So if a survivor wants to press charges, what are some of the steps they must take in terms of equipping themselves with legal help?
That can be quite complicated because, like you say, the state decides to step in and often the survivor is left helpless. And so I think it would be very helpful for a survivor to reach out to a good lawyer at the very beginning of things, because I understand that it can be a very traumatizing experience to start with. I know that it is, I can only begin to imagine how mentally draining it can be for one to go through that entire process. So I would say the earlier you get a lawyer, the better it is. So at the stage of filing the complaint or lodging the FIR itself, if one is able to get a lawyer to help them out, it would make things a lot easier. And like I said, there is a process that goes on after that, after the charge sheet is filed and magistrate takes cognizance of the offense, or if it's sent to a sessions court. Then at that point, obviously, you will need a lawyer to represent you and to represent your case. And in that case, I mean, there are so many forums these days. I think online forums, there are so many NGOs that are also ready to, that have a panel of lawyers at their disposal. So depending on what kind of crime you're approaching them with, I'm sure there are a lot of people who can help you out with that. So in terms of accessing legal help, I'm sure there is a bit of optimism. I think things are a lot better these days than they were, say, 20 years back. So that's what I would say.
Absolutely. Thank you for clarifying that, Sithara. So one area that survivors often feel the need to censor themselves in is just the fear of how many times they'll be asked to recount the incident they faced. The fact that they will be asked a lot of questions. So how does a survivor take safeguards against a legal proceeding that can only proceed if it knows what happened?
Well, I think this is a bit of a problem because you are time and again asked to recount the incident, which can be quite painful for a survivor, especially a survivor of, say, a sexual assault or something of a grave degree. It can be quite demoralizing for them. And also, not to mention that there are these notions of shame and morality that are often associated with these crimes. So that doesn't help either. So ideally, what happens is that when they go to lodge the complaint at the police station and at the stage of before an FIR is lodged or during, they would have to put down the complaint on paper and they would have to narrate the incident in their own words to the police officer at the station. So I think that is the first stage in which they'll have to recount the incident, which is why, to answer your earlier question, I'd mentioned that it would make things a lot easier for the survivor if they get the help of legal representative, so that if they feel like they're still in a state of shock and they are unable to speak about this, then they can always narrate this to a lawyer, and the lawyer will be able to assist them in taking them to the police station and putting it down either in a written format or narrating the incident. So that is one thing. And the second thing is when the trial is set in motion and when that begins, and we've all seen how a trial takes place, right, in movies, and of course not with the degree of dramatic representation, but we know how it works. We know that there is a witness testimony, there are witness testimonies, and they examine various they examine various evidences that are produced before them and all of that. So when the survivor is put on stand, of course, she or he, in some cases, will have to recount the entire incident and will have to narrate the story. And often we've seen that when a cross-examination happens, that is when the defense counsels were to examine the survivor, things start to get a little unpleasant, right? They're put in a very uncomfortable spot and they're asked a lot of uncomfortable questions to basically break their confidence and to shame them in some sense. We've seen this in a lot of cases, like the Tarun Tejpal case, for example, or even the Jessica Lal case. So many cases, like why was she there, what was she wearing, and whom was she with? These are all common themes. And I think one way to really tackle this would be, like I said, I'm going back to getting a proper lawyer to help you out. This not just helps you in the initial stages, it also helps you in the stages of trial, because at that stage, the lawyer will be able to give you some pre-prep and they'll be able to help you put the story down, in a proper sequence, and they'll be able to help you prepare for the questions that are going to be posed in court. So, you don't feel too startled or you're not taken aback when these uncomfortable or unpleasant questions are thrown at you in court. So I think those are some of the safeguards that will help.
Right. Thank you. Thank you so much for putting that in perspective, Sithara. So you alluded to the fact that there can be uncomfortable questions and even absurd statements to break the character of the survivor themselves. So is there something in the form of a safeguard that a survivor can bear in mind to object if something is presented as evidence against them just to break their case and their defense? What are, perhaps let me rephrase that better. What is inadmissible as evidence against a survivor?
Right. I think the Evidence Act is quite clear as to what are admissible evidence and what are not admissible evidence, and the CRPC also talks about it. So it is largely at the discretion of the judge when a case were to happen. Whatever is on books is slightly different from what really happens in ground reality. So the judge has a lot of discretion in this sense and can decide on what is admissible and what isn't. And in terms of evidence being used against the survivor, this happens more often than not. And often, evidence like, say, the WhatsApp chats and, highly confidential information can be used against them, or the WhatsApp chats or the mail history or messages or whatever can sometimes be used against them to often prove to the court that they are immoral in a sense. And a term that we often hear in courts is of loose character, and this kind of terminology, which is very depreciating. And I think survivors have to also be prepared for that kind of a scenario. As regard to what is inadmissible, like I said, the IT Act also has a few rules in place now. There was recently the Puttasamy judgment, which also spoke about privacy. So, like I was saying, when certain WhatsApp chats are used against the survivor, that can be inadmissible in certain cases because that is against the victim's right to privacy. So that is one point. And the second thing is that sometimes they also use, like I said, they try to character assassinate the victim. And the Evidence Act clearly says, if I'm not wrong, Section 53A says that the past character of the victim is not really of any consequence to the case. And there were also several judgments to this effect. A judgment that I'd referred to in an op-ed that I wrote about Tarun Tejpal. And in this, they say that Justice Bhanumati and Justice Indra Malhotra had written that they ruled on a case with regard to a prostitute who was raped, a sex worker. And they said that the victim's character should not be taken into consideration, and that consent is still a very important key element in these cases. So in that sense, what I'm trying to say is that the defense can't really say this person is of a certain character and has this precedent of, like having been with different men and all of these things. So these kind of evidences aren't really admissible in court. In terms of documentary evidence and all of that, there isn't really a cap.
Got it. Got it. Thank you so much for spelling that out as well. So my next question is, does the legal system expect a survivor to come face to face with the accused? Or are there any safeguards in place where the survivor does not have to meet the perpetrator?
Yeah. So unfortunately, the justice system has been designed in such a way that the survivor will, I think, more than once have to come in direct contact with the accused. And first, at the initial stages, when the complaint is filed and when the FIR is lodged, in cases where they haven't really been able to, or they're trying to track down the accused rather, the police conduct something called a test identification parade, where, like we've seen in movies, there's a lineup of people and then the victim, survivor, has to identify which person has committed the crime. So that is one instance where the victim has to come in contact with the person. And as I already mentioned, that can be quite traumatizing for the survivor. And secondly, also during trial, like I said, the victim is put on stand, and then the defense is also, the accused is also put on stand sometimes, and their version of the story is also heard. Obviously, our system functions on something called the principles of natural justice, where both sides are to be given an equal opportunity to be heard to avoid frivolous litigation. So in that sense, I think when a trial happens, the victim, there are chances that the victim will most definitely have to again come in contact with the perpetrator.
Right, right. Thank you for establishing that. In fact, I think that becomes a very useful place for the therapist or a mental health support person to be on call for a survivor, just to deal with the triggers it might bring to them. Thanks for spelling that out as well. Now, we've heard of a provision called mandatory reporting under the law. So one of the questions survivors often ask is, if they choose not to press charges but want to go get a medical exam, or they actually go ahead and get a medical exam, and then they find out that the doctor is under the law to report the incident. In such instances, does mandatory reporting force a survivor to press charges and go through with the process?
I think even then, there is no express provision to the effect that victim will have to press charges. There are certain incidents where, that requires you, like say, in cases of sexual assault or rape, where when you go to the police station to lodge a complaint, they then ask you, the police officer in charge then asks you to go get a physical examination done at a government hospital. And this is, of course, assuming that you're proceeding with prosecuting the person, because otherwise it would be a pointless exercise, because if you don't decide to press charges, it's absolutely your prerogative if you choose not to do it. So when you do go ahead and file the complaint, this is almost a matter of norm that they ask you to go to a government hospital and get yourself checked and examined to see if there are any bruises or any bleeding or something like that. So I think in some cases when it is reported by the police station, they do have a certain protocol for government doctors to follow. And in those cases, they might have to proceed with the series of events that were to follow. But otherwise, if they decide not to press charges, then I don't think there is any mandatory rule.
Got it. Thank you for spelling that out as well. So how long does a typical legal proceeding take in prosecuting sexual or gender-based violence? Is there a fast track to it, or is it something that just takes its course?
Well, that's a very difficult question, considering how erratic a legal system can be, rather. So there are fast track courts, and with matters of grave importance, the fast track courts came into being for to try crimes like these, which are of immediate importance. But be that as it may, we see that ground reality is a little different, and cases aren't. There are a lot of backlogs, and all cases don't go to fast track courts, and also I just want to point out that when we talk about here, we're talking broadly about crimes against gender-based crimes or crimes against women, let's say. But there are various categories to it, right? There are so many kinds of crimes. When we talk about that, there are crimes of smaller degrees, like say cyber stalking or something like that, or regular stalking. And then there are higher degrees of crimes like sexual assault and rape, and then domestic violence, which happen within a more intimate family setup, or even marital rape for that matter, which is not illegal, by the way. So there are so many things, and the process for all of these things can often be very different, and all of them won't be tried under a fast track court. But a lot of the times we see that crimes against children, like sexual abuse cases against children, which fall under the POCSO Act, some of them are, most of them are tried under the fast track court. And in fact, last week there was a verdict by, if I'm not wrong, the Orissa District Court, where it was the fastest ever criminal trial that happened. They disposed of the case within a day. It was a rape of an 8-year-old child, and they heard and disposed of the entire trial in a day, and they convicted the person and gave him a life sentence. So we've seen that. And we've also seen cases like the Jessica Lal case and Nirbhaya, and we've seen cases that go on for a decade. And So that can also be very mentally draining and demoralizing largely for survivors to approach the justice system. But I'd say that the courts do tend to do good work as well, and they do try to somehow tackle the backlog, and they do try to render justice as much as possible. Like recently, even the skin to skin contact, the verdict that was rendered a couple of months or nearly a year back, I think, where they said that, where a court held that skin to skin contact would not constitute as sexual assault under the POCSO. Recently, the judgment was reversed by a court, and they said that that would constitute sexual assault. So I think things are changing very slowly in that sense, and that is the state of affairs at the moment.
Absolutely. One hopes for that change to sustain. But before I let you go, my last question to you, Sithara. What if a survivor is not happy with the decision of the court? And there is a route to appeal, but how soon or how late should that appeal be filed? And does it involve producing fresh evidence?
Right. So there is a general, we have something called the Limitation Act, and there is a general limitation period for civil cases. But when it comes to criminal cases, the limitation period is often different, and the IPC and the CRPC largely govern it, and limitation period does not really apply to certain cases. And the limitation period is also, and the appeal is also, the process is different when it's, say, a case of conviction and a case of acquittal. So, and it also depends on what kind of a crime it is, if it's a cognizable offense, if it's a non-cognizable offense. So there are lots of layers to peel back there. But largely, the justice system does allow a victim to appeal, to go on appeal against the order of the trial court if she is unhappy with that order. And mostly the appeal period is between 60 to 90 days from the period of the original order. And what happens is that the High Court will have to grant a special leave for the matter to be taken up on appeal. And all matters are not generally taken up on appeal. So usually what happens is that, and for it to go to Supreme Court, which is, as we know, the apex court in the country, on second appeal, it has to satisfy certain conditions, and the High Court will have to grant a certificate for the matter to go on appeal. So largely, the power of the appellate court is to review the law rather than conduct a fresh trial. So it is mostly to correct, something of grave injustice, and the way a trial court has looked at and the way it has examined a certain point of law. And when there's an error in that point of law, the appellate court has the power to correct it. But in terms of, it doesn't really function as a court that conducts fresh trial. So in that sense, fresh evidence would not have to be produced unless the leave of the court can always be sought if some evidence of great importance has surfaced, for instance. Then the leave of the court can be sought, and that evidence can be produced before the court.
All right. Thank you so much, Sithara, for your patience and for the wisdom that you brought to this conversation. I'm very certain that it's also dispelled a lot of myths, a lot of lack of information, both among active bystanders and survivors alike. Thank you so much for making it and for giving us your time and emotional labor in this conversation.
Yeah, thank you so much. And I'd like to say that the initiative that you've taken is so very important for what's happening at the moment, and in terms of tackling gender-based crimes. I think it's a platform like this is very important. When you told me about Sahas, I was immediately interested in doing something like this, because I think more often than not, we talk about these things, we rage about them, we talk about them, we write about them in my case. And that's a way of sort of, holding the system accountable. But seldom do we actually do something about them and try to create a platform where survivors can actually reach out for help. And I think that's very important, because I think from what people read in general, they're a little skeptical about, just approaching a police station and lodging a complaint, because they feel they'll be shamed, or going to the court and prosecuting. I think I think what you're doing is very important in setting that in motion. So thank you for doing what you do.
Thank you, Sithara. That's very, very kind of you.